started. I want to be respectful of Drew's time. So thank you everyone for joining our afternoon call. We're really excited to have Drew Bowling here with us today. He's the Assistant Director at the Lexington Fair Housing Council. They are one of our sites this year, so we're excited to have members placed there delivering services to all the people that Fair Housing serves. So with that, we're going to hand it over to Drew to take it over.
Thank you. So as Caitlin mentioned, my name's Drew. I use all the masculine pronouns. I'm going to talk to you for the next couple hours about fair housing, what it is, what we do, and how you can recognize it, how you can see that it's practiced at your site agency. And also there's some information in here too that you'll probably find personally helpful as well. Throughout the training today, there's going to be opportunities to utilize the chat to ask questions. I'll be kind of checking in with the chat probably about after every section that I go through. There'll be some scenarios on here as well. You can just use that to, one answer, situations where you say like, you agree, or this is compliant, or that's not fair housing. And then, after them, if it seems like there's some spirited disagreement, we might I might just hold some space and ask you to unmute, and we'll talk a little bit about it. But really, the goal of this isn't really just teach you what the law is. You could probably read that. Also, reading legal stuff is really pretty boring. So I'm here to talk to you about like the application of the fair housing law. I am a social worker. I'm not an attorney, but I work for an attorney here. And yeah, as Caitlin just mentioned too, there was a packet of handouts that was sent to everybody. It's going to be related to all the stuff that I'm going to talk about today. Obviously, nobody should ever be expected to remember everything I say today, but hopefully those handouts are going to help be like, like bookmarks or, things that are going to like trigger some memory from this talk that I had with you when you have to go over that again. So yeah, with that, I'm just going to roll right into it. Like I said, my name's Drew. I am I am coming from what is currently known as Lexington, Kentucky. But actually, this is the unceded land of the Wasatch, Cherokee, and Shawnee people who were here before the Fair Housing Council or anything else was here. And what I'm going to talk about first is really who we are. Like, why have I been invited to come talk to you? So, like I said, we are the Lexington Fair Housing Council. As I just mentioned, we're in what is known as Lexington. But we're actually a statewide agency. We serve people throughout the state. So whether or not your site is in Lexington, it doesn't matter. As long as you're in Kentucky, we're a place that can probably help you out or help out a client of yours. So this is going to apply to not just where you're working, but also, maybe you as well. So we take clients from, as they say, Paducah to Pikeville and everywhere in between. What our primary job is, that what we do is we legally represent people who have been victims of housing discrimination. That can be mediating some disagreements between a tenant and a landlord. That can be initiating some systemic investigations into housing practices rooted in the decades or centuries long practice of redlining and steering and segregation. We sometimes do trainings like this. This is one of the things that I like to do personally. This kind of training and like training for like tenants and stuff, it kind of helped them recognize what is not okay and what is okay and what landlords' obligations are when they when they're out there on their own. We do actually legally represent people in civil lawsuits. Sometimes these are things that we will file with like a Human Rights Commission. We have filed federal lawsuits that have been we've partnered with the Department of Justice to file those. So yeah, we've made some pretty big cases in our time. Another thing we do is utilize volunteers to help us investigate discrimination. A lot of times, unfortunately, and nobody should be expected, that like when someone encounters a situation where they feel like they've been discriminated against, it's hard to really know how to collect evidence for that. So I actually manage a big team of volunteers across the state to have them go out pretending to be renters or home buyers And I pair them up, and they basically report back information to me, and I pair them up based on what I'm trying to determine as the discriminated identity. So for instance, I might send a white tester and a black tester to go talk to this property manager, and they're going to have all the same information except for one thing. The property manager is going to see one person's white, one person's black, and I want to make sure they get treated the same. And like I said, we're also a resource for the housing industry. We do a lot of landlord trainings for cities, real estate companies. So it's sometimes easier to get ahead of problems before they happen instead of afterwards, because we can help folks unravel some sticky situations if, you know, they contact us and we're helping them out in them beforehand, and they kind of know what's fair housing compliant, what would be a violation, versus like it's after the fact, and now we probably can't help you because it's a conflict of interest, because our interest is in residents, is in tenants, and in home buyers. So this is like the simplest agenda ever. What we're going to do, like I said, I'm going to talk about fair housing application, and we're going to go a little bit deeper into each of the protected identities. I'm going to tell you about what that is and how each of those encounter discrimination, because it's not always the same depending on what the identity is. Probably around, I should actually say 2:30, not 1:30, but around 2:30. I'm probably going to take in a break because I'm the only one doing the training today. This is a little lengthy training. So I think I will need a break about then. You might need a break about then. And just kind of refresh ourselves, come back and finish up, and hopefully we'll be done around 2:45 or 3. So a little housekeeping stuff. For one, I want to go over a little bit about how we talk about folks who have identities that maybe we don't share. This becomes important, especially if you have a privileged identity. So using people first language, people of color, people with disabilities, a person with a substance misuse disorder. That's just the way those communities have chosen to talk, have told us privileged people to talk about that. And so, we just want to respect that. And yeah, Caitlin's got an example right there. We don't want to affix something to someone and define them as the thing. It's always going to be people first. We're going to talk a lot about disabilities and folks with disabilities. I've been in places where folks, even though they might be covered with under fair housing law as having a disability, don't even identify themselves as a disability. So always allowing for different descriptions or identifiers for that kind of, for someone's situation. There was a guy several years ago, as a client of mine. He was actually an Olympic wheelchair basketball player. And I asked him, how do you describe your disability? And he said, I don't have a disability. I just have a C4 vertebrae fracture. And that was it. So again, I was really glad I asked that, because I didn't want to be talking to him and be like, okay, since you're a disabled person, like that could be really harmful and probably would have damaged our relationship to be able to work with him. That said, there's outsider identification versus insider identification. Especially among like older folks, you might hear language that might be considered outdated. You see a couple of examples there. But really trying to use that people first language. And if you don't share that identity, I encourage you not to correct that person because they're using maybe what we consider outdated language. Empowering language versus disempowering language. So again, talking about someone who is experiencing homelessness, someone who has a disability. I hear this a lot, not just with landlords and stuff, but just in the community, as someone who might use a wheelchair for access, somebody describes them as impaired. And we have to really kind of change our thinking around that. There's no impairment. It's just that most of the architecture in this world was not actually created with any thought about who could use that if they were not able to walk up steps or didn't need to use a rail. So really the impairment's not really in a person, it's really in the way we've constructed our world. So I'm just gonna I'm not gonna gently say it. I'm gonna say, don't describe people as impaired, especially when you're talking about if they have any kind of disability. And then it also comes with folks who maybe are living with an addiction or have been through recovery programs, referring to those folks with like people-centered language and not referring to them as like addicts. They might call themselves that, and that's okay because they can self-identify. But just making sure that like we're not perpetuating harm by fixing stereotypes that maybe they don't want on them. or fixing labels that they don't want on them. So that's my spiel. That's how we're going to talk about all these folks, because it's very important for me, because a lot of these identities I do not have. So we have to be very thoughtful about how we talk about these issues. So what is fair housing? I think all of you probably know what fairness is when it comes to like, did that person cut in line when I was at the store? I didn't get charged as late fee, but this person did, and they're really mad about it. So, you know, we have an idea of what fairness is. For the purposes of fair housing, it is a very specific legal term. So just because a landlord decided to not renew my lease, but decided to renew the lease of the white guy that lives next door to me, like, that's not really, that's unfair, but it's not a fair housing issue. Fair housing is very specific to identity. And so I'm going to talk a little bit about that. This is basically the legal term for what the Fair Housing Act is. Happened in was passed in 1968, and it's been updated a few times to the point that now we have really, I would say, 9 identities that are protected under the Fair Housing Act, and that's what we're going to talk about in detail today. But like I said, we're talking about application, not what the law calls things. So there's 2 parts to fair housing law. So the first part, the definition of housing discrimination starts with, I'm a landlord, I'm a realtor, I'm a lender. I observe one or more following characteristics about a person that has approached me for a housing transaction. I could see that they are a woman and I am a man, their skin color, maybe they wear something that indicates a religious practice or belief system. Maybe they have kids with them or something like that. So I'm observing one of these 7 things, or maybe more than one of these 7 things. And then, based on that observation, the next thing I do is decide to do one or more of these things because of that person I just observed in that identity. So again, refusing to sell or rent somebody a home because of one of those 7 identities, subjecting them to different terms or conditions, maybe just lying to them and saying, no, it's actually not available anymore, when in truth, the property really is. Retaliating against somebody because they thought they maybe had been discriminated against. Maybe they contacted our office and we intervened. Spoiler alert, a lot of realtors and landlords don't like it when they get calls from us, because it usually means they're in trouble about something. And it's usually not hard to identify it, or in fact, we might even identify the person because that's for a legal representative. So anybody who would retaliate against somebody because they sought out our services, that is expressly illegal according to the fair housing laws. Maybe steering somebody to certain properties, or even just different properties altogether, or different apartment buildings on the same complex. And then also advertising, advertising in a way that discourages or denies people from seeking out a housing opportunity that otherwise maybe that would have been a perfect fit for them. You see this sometimes in, you know, Facebook Marketplace ads. I don't know if anybody still uses Craigslist. I know there are listings on there. I'm kind of an elder millennial, so I don't know what the Zoomers are doing. But you know, you would see discriminatory ads on there as well. So again, what does it look like when you combine this one and this one? Well, basically, let's put it together. So maybe like I deny that a home is not for rent, but it actually is, because when either I talk to somebody on the phone or I even see them, I kind of coded that person as black and I'm white. So again, I can't be treating that person differently because they're black. I might try to say that, like, you know, oh, you know, they didn't qualify or whatever. But that's where our investigation will come into. Charging a higher security deposit because maybe a tenant uses a wheelchair. Some landlords will argue that wheelchairs cause damage to places and so forth. And again, that's not the problem of the person who uses the wheelchair, because they need a place to live, and you're not going to be able to just, by charging somebody more money because they use a wheelchair, is in fact treating them to different terms. You know, you're basically created a higher obstacle for them to obtain that housing than, say, like me, who can just walk into the place. If a tenant has children, maybe, you know, this isn't a secret, kids are noisy. And so, you know, if you put them on a 2nd floor apartment, you probably know, maybe some of you even live below a family with kids, you know, they're going to be making noise and stuff like that. And a landlord might be trying to cut off that problem in the beginning and not even show them 2nd floor apartments. in effect, basically saying we don't have any properties available for you, which again is not something that landlords can do. You have to show them any available property, and then try to resolve those issues if they come up. They're not even guaranteed to come up. And again, retaliation. So sometimes landlords, after they get a letter or a call from me, they might threaten to, I'll find out from my client that they've gotten a 30-day eviction notice. Again, that is retaliation, and it is expressly prohibited in the fair housing law. So again, these are the 7, and this is actually a little outdated. I'm going to tell you why. So these are the 7 protected identities that we've had up to this year. Because earlier this summer, there was a really important Supreme Court decision, and it involved workplace discrimination on related to folks because of either sexual orientation or gender identity. It actually, the courts ruled in favor to protect against discrimination for folks who either gay or queer identified, and also trans identified folks as well. So actually, that kind of opened us up to have a whole new group of folks that we now can represent, because before, federally, they weren't protected. Before, you might have heard of fairness ordinances, like Lexington has one. I forget which cities had one, maybe Frankfurt, Danville, Moorhead. The cities had passed local fairness ordinances to add protections for folks against discrimination because of either their sexual orientation or gender identity. But this Supreme Court decision has actually opened this up so that now we can do this all over the state. Our attorney's been pretty fervent that, like, yeah, this means that we can represent folks wherever. So you might be thinking, what did that mean before? What that meant was pretty much in most of Kentucky. So they're like 17 or maybe 18. I forget how many they had gotten up to at that point. Before the Supreme Court decision, there were 17 or 18 cities or counties that had adopted fairness ordinances. And Louisville, Lexington, a couple of places in northern Kentucky, like I said, Moorhead, Danville, Vicco, Kentucky. But what that means is, for most of Kentucky, you were not legally protected against discrimination if a landlord either knew or presumed that you were gay or trans or queer identified or gender expansive, and legally, on paper, that was allowed. So this is actually a really important moment for us, because it's just broadened that protection for everybody in the state. So yeah, I talked about these 2 in the blue being recently added. Other places will pass fairness ordinances, or we're not fairness ordinances, but I guess non-discrimination or anti-discrimination ordinances, because people might be discriminated against because of their marital status, because of their age. Actually, age is protected in employment, but it's not in housing. Source of income. So if you use a voucher, like a Section 8 voucher, or you have what's called a TVRA program, some of the agencies you're at might talk about those. These are housing assistance vouchers for folks who live in poverty and just need help with their housing. Currently, everywhere in Kentucky, it is totally fair and legal for landlords to say, oh, wait, you got a Section 8 voucher, I'm not renting to you, because there's no protection for those folks. So that is actually a big problem, and it's the result of that is we more often than not see segregations of poor, usually brown and black folks in historically segregated neighborhoods because of that lack of protection for folks who use housing assistance. So I'm going to play a little game. You are encouraged to use the chat, but because there's so many people in here, it's not going to really be feasible to kind of ask people to unmute and tell me and have a discussion. So this is going to be a little preamble game we're going to play. You all are getting an edition of this that I like to call the office edition of our training. So we're going to go over a few scenarios. For those of you that don't know, this is Dwight Schrute, assistant to the regional manager from the show The Office. Watched it a lot on Netflix. I think it used to be on NBC. And basically, I'm going to present to you several different scenarios here in a few minutes, or over the next few minutes. And basically, we're going to just kind of make note: is this what just happened in this scenario fair housing compliant, or is it a violation of fair housing law? you're not really expected to know this right now. But again, I'm just going to kind of push you to think about this a little bit before we get into it. And it's also kind of meant to maybe help you identify some ways that you currently think about it. And hopefully we can, improve that or change it or challenge it and however it goes, okay? So again, if it's fair housing compliant, Dwight Schrute looks really smug and satisfied. And if it's a violation, he is very upset, okay? So for the first one right here, well, actually, I lied. I'm giving you one more chance to kind of review the 7 protected identities here. Like I said, this is outdated because the Supreme Court ruling earlier this summer added sexual orientation and gender identity to the national protections against housing discrimination. So, all right, that's your last look. So, first one, the owner of a mobile home park that is mostly populated by Latinos fails to maintain the property. So think about it for yourself for a second. Is this a fair housing? Is this discrimination or is it not? You can feel free to add comments or thoughts, reactions in the chat. Like I said, we'll check in with it every now and then. But somebody said compliant, and in fact, Abby, so spoiler alert, Abby and Terrell are 2 of our AmeriCorps here, and they've actually already been through this. And so actually they have been eating and breathing fair housing for a while. They have this stuff down. So I'm also going to embarrass them a little bit and say, if you ever have fair housing questions within your AmeriCorps cohort, they're really cool, good people to seek out information from because they will probably know this. So everybody says compliant, and well, at least everybody I can see right now, and I think you're right, because in this scenario where this is all the information we have, this could just be one of those people that we call an equal opportunity slumlord. It doesn't matter who lives there, they're not going to take care of it. Now, if we were to find out that this mobile home park owner had another one that was on the south side of town and it was much better maintained, then we have an issue. Because I want to know why one that has more melanin than the other one is being treated poorly and differently. Terrell, you got that one too. Okay, so a landlord can charge a higher security deposit for families with children because there will be more wear and tear on the unit with children living there. Again, this isn't an untrue statement, but it is, as you all are saying, a violation. Dwight's not happy about that. So you can't create obstacles for folks based on the fact that they have kids. Familial status, we're going to talk a little bit more about that, but it is defined as you're going to be having children under the age of 18 living with you. Could be your kids that you had that are biologically yours. It could be adopted kids, foster kids, grandparents, or grandkids. So again, it's just, like I said, anybody under the age of 18 who is legally considered a minor is going to be living with you. That's familial status. Property manager can require a blind tenant to live on the first floor for safety reasons. Well, that's not maybe an unsafe idea, but at the same time, that is also limiting somebody's access and opportunities to housing. So Mr. Schrute is pretty upset about that. The reason that is because we don't know the extent of this person's visibility. Some people who are considered legally blind might still see okay. This person also might have, like I said, architecturally, this world is not built for folks who are not like totally able-bodied and have no visible disabilities. So, this person might be pretty adept at navigating that really ableist structures and architecture in the world. Maybe it's not going to make a difference to them. The important thing is a landlord can't make that decision for somebody, okay? A landlord may evict a tenant with a disability who sets fire to a stove because the tenant is a risk to other tenants and to the property. So this one always is a tough one, right? Because you don't want to treat people differently because of their disability. And I see a lot of folks are saying that this is a violation. So this is a little trick question, but Dwight doesn't have a problem with this. And the reason he doesn't have a problem with it is, at least on this information, the fire that was set on the stove, is not related to the fact that that person has a disability. As seemingly cruel as it can seem, someone with a disability can be evicted if they have violated the lease in some other way. Now, again, there's always more information that can be gotten. You know, maybe this person requested some changes to their apartment, what we would call accommodations or modifications, which again, that's something we're going to talk about in a little bit. But maybe, you know, and this was an issue that wasn't resolved by the tenant and or wasn't resolved by the landlord and the tenant, you know, this was related to the disability. Again, we would need more information for that. But based on this, there's nothing related to the fact that that stove, there was a fire on it and that person had a disability. I could have also set that fire on the stove, and I would also be evicted. So again, there's some nuance in this. But yeah, like Office One said, I'm going to assume that was already your name, and it's not because I'm using Dwight Schrute pictures, but it's pretty funny continuity. But yeah, like you said, you need more information about some things. So I think this is my last one here. A landlord can refuse to rent a 3-bedroom apartment to a family, which includes 2 parents and 4 children. And in those children, 3 of them are boys and 1 of them are girl, and all of them are under the age of 18. And the landlord can refuse this because the boys and the girl are not allowed to share a room. This is actually a violation. Again, landlords can't make those choices for people about if children of different genders or sexes share a room. You just can't. And that is a very common problem that we have. It comes up a lot. And some landlords will, I don't understand it, but that is a sword they're going to fall on. And, you know, they're just like, I don't care, you can sue me. I just don't think that's something you should do. And yeah, that is not a thing. Kaylee asked, unless HUD is paying for it. And actually, that's not, this would still apply for public housing as well. You might be asking that because you've encountered public housing that has said that this is in fact one of their rules. And we've actually had to get involved in those. Government bureaucracy, some public housing agencies do follow some of these rules and other ones don't. So yeah, even if it is federally funded, their policies may still be fair housing non-compliant or fair housing violations. So the big takeaway from this, like we just talked about in the chat, and I've said, like, there are situations where there might be more information. And I think that's best summed up by this. Fair housing is a process. It's not just a thing that happens and then after that, that's fair housing. It's that easy. So again, there is constantly this movement going with fair housing. Sometimes there are cases that don't seem like fair housing at first, but then actually they become a fair housing issue. Maybe sometimes because of the change in the law. Like I said earlier, there's new kind of expansion this summer. The law sometimes gets changed and is updated, and you know, it is an event. It's also an event because staff changes at places. Landlords, people who weren't landlords before become landlords. A little bit of trivia for you here. There is zero regulation for what is needed for somebody to become a landlord other than saying, I want to be a landlord. I can just go and start renting out a place that I own, and I don't have to have any kind of inspection. I don't have to go under any kind of training. There's no certification or licensure. In fact, the person that cuts my hair, which I don't have a lot of right now, but the person that cuts my hair is more trained and licensed by the state than the person I rent my home from. So yeah, so a lot of landlords don't even know the law in this industry that they're getting involved in. So yeah, it is a process, and it's an ongoing process. And for us, it's a process we repeat a lot because we just encounter folks who, again, are making the same mistakes that we were dealing with 2 years ago. All right, so these are the full 9 identities that we're going to talk about. It is about 1:30, and I just want to check in with folks. Using the chat, does anybody have any questions about any of those scenarios we just went over? And if so, we can take a minute to talk about it. Otherwise, I'm going to go ahead and move on. So I'm going to give that maybe like 30 seconds. I'm going to take a drink of water, ask a question, and then I'll just come back, okay? I am going to say that everybody's good. Kaylee's good. Gabrielle doesn't have any questions, so we're all getting it. We're going on. So let's see. Every time I click on a new window, something changes on me. So we're going to talk about these three together, because not because they just don't need as much time. Actually, these overlap more often than not, and these are actually some of the oldest identities that have been protected. Originally, there were only four identities in the Fair Housing Act when it was made a law in 1968. It was race, skin color, religion, and the other one was national origin. Sex and familial status weren't added until the late 70s, and then disability wasn't actually added until the early 90s. Y'all may have heard of the Americans with Disability Act, passed in 1991. That was when disability was also added to the Fair Housing Act. So it hasn't actually been all that long that it's been protected in housing. So race, skin color, and religion. First, we need to talk about what is overt discrimination in housing and what is covert discrimination. What is something that maybe is harder to determine if it's actually discriminatory or not. And this is not limited to just because of somebody's race or skin color or religious practice or beliefs. This applies to all of them, but I think it's it's good to introduce this concept pretty early, because again, it will apply, but I want to talk about like how racism, specifically anti-Blackness, colorism, and other things like this kind of get written into policy so that it's not actually so obvious that it's a discrimination. But overt discrimination, that's basically you state a preference for tenants based on their actual or perceived race. So if, you know, a brown woman who see up an apartment and she arrives and it's a white woman who is the landlord, and the landlord says, hey, you know what? We don't rent the non-white people. So actually, I can't show you the place. That's really also really awful to say. That's also very overt. Like that makes my job easy, right? Because that person didn't really leave much to investigate. They said that thing, and that's a case right there. It could also be, you know, maybe they'll rent to them, but they're going to treat them differently. Maybe they'll steer them to, maybe it's a big apartment complex, and they're going to steer them to the very back building, so that when new tenants come in or anybody else that's coming to that property the Black and brown people are out of sight. They're in the back, so you don't see them. And some people do this because they think the appearance of a white community will make it more appealing, or maybe make it easier for, you know, to rent out other places. You could also be charging them different rates of rent. Cooking is a thing that comes up a lot with just ethnicity in general. We've had landlords who have been talking to a prospective tenant. One recently, she was Haitian, I think, and she was looking at a place, and the landlord said, well, what kind of food do you cook? Which it was kind of a weird question. I've never been asked that. And basically, the landlord asked this question and then went on to say that, well, he didn't like renting to people of different ethnicities because the food leaves a weird smell, and he doesn't, it costs him a lot of money and it bothers people. But what he did say is he'll rent to this person, but he's going to make it a 2-year lease instead of a 1-year lease. So there's all kinds of bad things going on with that, right? And that's actually a case that I'm investigating at this moment. So yeah, this comes up, and treating people differently, making them sign longer leases because I guess you think people of this race or of this ethnicity are just more likely to not pay, or, you know, going to make more damages and so forth. Can't do that. So institutional stuff, that's like stuff that's written in policy, right? Like you hear a little bit about unconscious bias, and, you know, unconscious bias is really one of these things that kind of come around to, like, I used to think maybe we could train our way out of it, but I don't think that's actually going to work. Like we have to institutionalize it with newer policies that we imagine without that unconscious bias written into it. This is one of the really cool things, though, about fair housing law. So, for example, if I write a policy that says no criminal activity can be at this property, you will be given a 14-day notice if the cops come to your place. applies to everybody. Everybody signs that same lease. It's that same clause in there. That seems like it's fair, right? I'm saying I'm treating everybody the same. It applies to everybody. However, there could be some reason that that's going to have different outcomes for people, even though that intent is the same for everybody. The outcome could be that there's one black tenant and somebody just thinks that, you know, the two black men that live there are scary and calls the cops on them. Cops come there and they're going to maybe get an eviction notice. It could be that somebody who's experiencing interpersonal violence, they could, sometimes they call the cops because that might be the thing they feel like is going to save their life. The cops can come to the property, and again, it's going to be a violation of that of that lease, and they're going to be faced with an eviction notice. So again, they might have the intent to treat everybody differently, but the outcomes, equal opportunities don't always mean equal outcomes, and that's the thing with disparate impact. That's the part of fair housing law where we're allowed to actually look at what is the outcome, not the intent. There's a question about what rights do property owners have? It's their property. They have a lot of rights, actually. There is in Lexington and other places within the state, there's a thing called the Unified Residential Landlord-Tenant Law. They have, that's codified as like what landlords are allowed to expect of tenants and what tenants are expected to do for their landlords. For most of Kentucky, there isn't any kind of law regulating leases or anything like that. Like I said, landlords for the most part can just kind of create the leases as they want. There's nothing regulating it says that's unlawful. I've seen leases where landlords have written in there that by signing this lease and living here for 12 months, you waive your right to a jury trial, which is in the Bill of Rights. So again, landlords will do things like that. It is their property, but as it's, you know, the other thing is it's the law. So you can't just, you know, just because I want to live with other white people or want white people to live in my property, that's just not something you can do. And if that is something that somebody disagrees with, that might not be the right industry for them. So again, there are certain laws and protections for this because of the anti-blackness and the racism in this country. So just because you have property you want to rent out, even with the lax laws and lack of protections for tenants, again, there are certain things you have to follow because for better or worse, our country has passed laws that try to make access to housing easier for folks who historically were denied it and they didn't have any protections about it. So here's another example. This is a sign. This wasn't from 2020. That's actually from Detroit in the 50s. Pretty overt discrimination there. And this was actually before the Fair Housing Act passed. So back then, this was legal. This gets written into other policies somehow, or in some ways by being more discreet or covert. So the example I have here, a lot of applicants or applications for housing will ask if you have any criminal background activity. That's really vague. And so if it says, you know, something pops up on your background check that you paid for, and it shows that you had an arrest or, you know, you were charged, but maybe it was dismissed. Landlords and property management companies have said that that's a disqualifying criteria. You can't rent here because of criminal activity. Whether it was 20 years ago, whether it was 50 years ago, doesn't matter. They will have a zero tolerance policy on this. What we know now, there's been a lot of research, it's been very heavily talked about, is the over-policing of Black and brown communities and the disproportionate effect, or number of folks who are Black and brown in this country who have had interactions with law enforcement. It is not equal to the percentage of the proportion that those of the general population those communities make up. It's actually really high up. So what happens with that is you end up with a protected group of people because of their race who are overwhelmingly experiencing this thing at a far higher rate than, say, like white people are. Again, it's not that white people don't experience this, just disproportionately, a higher percentage of Black folks compared to the general population are experiencing this than the population of white folks compared to that general population. So a few years ago, this new guidance was issued to housing providers, to landlords, that says you can't just use blanket criminal background checks anymore. Well, for one, let's distinguish between arrests, charges, and convictions. Be a little vulnerable here. I've been arrested. I've been to jail. I wasn't charged though, so it was dismissed. But theoretically, if that were to be looked up on my record, I could be denied housing simply because of that. And again, like I said, this isn't that it doesn't happen to white people. It's just more likely to happen to Black people. So again, landlords are now required to look at not just arrests and charges, but were there actual convictions? You can get arrested for anything. The thing I got arrested for is really stupid, actually, but I wasn't charged, so it was dismissed. So you're basically going to say that because this person was found not guilty of something, the fact that they were even charged or arrested in the first place, they're still not fit to live in this community where I want to keep it safe. Even though legally nothing has been determined that this person has some reason to present harm to this community you're renting to. The other thing landlords and property managers have to do now is they have to be able to justify the exceptions to this. So, for example, somebody who wrote a bad check 35 years ago and has a felony for that, that's going to be, and that's the only thing that comes up on that background check. That's going to be hard for a landlord to defend when basically the purpose of these blanket no criminal background activity rules is intended for a safer community. Now, if it was breaking and entering that somebody pled guilty to 3 years ago, they can defend that. That's in the interest of the safety of the community. So again, that I can understand a little bit more. But the person, like I said, who wrote a bad check, or maybe had just like a minor misdemeanor possession charge 5 years ago and has been off the criminal radar since then, again, that's going to be a little harder to argue as a reason to disqualify that person from renting there. So another one that HUD came out with in 2016 was that not only can landlords not be doing harassing things or discriminatory things to people, but if there becomes an issue between neighbors or other tenants of yours, that there's a situation that's related to somebody's identity, that could be a fair housing issue that a landlord needs to respond to and try to resolve. So let me talk a little bit about what that means and what that doesn't mean. If I live in an apartment complex and I really like parking in this place before Pete, over in front of Pete's apartment because it's in the shade, and I just always try to get there and I try to park there, and Pete doesn't really like that. That's just a problem we're going to have between ourselves. It's not because of my identity. It's not because of his identity. It's just a tenant issue. And, you know, the landlord might tell us to try to work that out or some way. And that would be it. They wouldn't have any obligations for that. If I liked to park in front of Pete's apartment and then put up my neo-Nazi sunscreen protector thing and had my Confederate flag and always parked really close to his car in front of his parking lot, and you know, Pete felt like this was targeted because Pete's Black, that's something that a landlord might need to step in and have a little more direct intervention on. Again, it is like a freedom of speech thing, but when it becomes a hostility and it's targeted, that becomes a fair housing issue. Sometimes, you know, a dispute that doesn't start and is a fair housing thing maybe can, you know, maybe people of two different ethnicities or races are arguing and it was just about a parking place, right? But as soon as somebody says like some slur or some hate speech or does something, well, then it's not about a parking place anymore. Now it's because that person's Black or because that person's Latinx. So again, landlords have a bigger obligation to respond to these and try to resolve them if it is related to somebody's identity. And I just kind of talked about like, what does it look like when it's just a neighbor altercation or a dispute, and it doesn't have to do with a person's identity. If I'm just somebody who I've decided like, I don't have kids of my own, I don't like kids, I don't like to be around kids, and I'm just always particularly nasty to this person who has kids, and I go out and I like let the tire out of the kids' tires or something, or let the air out of the kids' tires, or leave them nasty notes and stuff like that about, I'm going to call CPS on you and all this stuff, because I just don't like how close their kids get to me. Like that could be a fair housing problem. I still don't know what kind of monster would just go let the air out of a kid's tire too. I don't know them, but they're out there. I'll tell you that. So the last thing, like I've talked about, religious affiliation, belief, it's also protected under the Fair Housing Act. And all the stuff I just talked about with like harassment and neighbor on neighbor harassment and stuff like that, ethnicity, cultural practices and stuff, maybe related to food, all that also applies to like religious beliefs, right? Like somebody who might just burn candles in a place, right? Maybe have an altar or something like that. A landlord couldn't just put those stipulations in about like, well, you can't burn candles because, I don't want you to catch fire, but like really isn't enforcing that on anybody else. Has just made the assumption because maybe this person wears a scarf or is dressed in a certain way, and it's just assumed that this person's going to do this and, makes that statement or even adds it to the lease. So this isn't to say that you can't also have your own beliefs, your own practices. Obviously everybody does, and for the most part we can just go through the world. There are places that are actually called like Sayer Christian Community, or names like that in the property, and that's okay. It's more about the practice of fair housing and not stating a preference of certain folks, because as long as they'll still rent to everybody, that's less of a problem than it is if they were just like, well, this is a Christian community and we ask people to verify what church they go to and need a letter from the pastor before we'll let them rent here. Like, that's going to be a bigger issue. So I just talked about this. I'm going to skip that because I just told you the answer to it. Dwight said that he doesn't like it if the place says it's a Christian community rather than, Christians just in the name of it. Second one though, so let's say you're a property manager, you put a Christmas tree up in the common area, like the leasing office or outside of it, and you hang up a banner that says Merry Christmas. So what do you think Dwight's going to feel about that? Is that fair housing compliance, or is that going to be a violation? And this actually is not something that is going to run afoul on fair housing. This is really nuanced because, that's, practiced in this country cross-culturally. Now, if you put a nativity scene up there and start advertising for Bible readings and stuff, and, that maybe starts to get into a little territory of like, you might not want to do that far. But Merry Christmas and a Christmas tree, like those are things that at least our office has no problem with when it comes to fair housing. So I mentioned the last one, national origin. So what this is like I said, it was the fourth of the original 4 protected identities. So what it is and what it isn't. So what it isn't is about immigration status. Anybody who resides in the United States has fair housing rights. It doesn't matter where you are in immigration, if you have what is documentation that's recognized as legal or not recognized as legal, it doesn't matter because you have fair housing rights. Now, there are obviously different risks involved with getting involved with the legal system, depending on what documentation you have and what the government wants to accept as legitimate or not. But it's not about immigration. It's more about like where your family's from, cultural practices, ethnicity, maybe accents. Maybe English isn't your first accent. We in our industry call that limited English proficiency. So basically people for whom English is a second language. And I am really happy I learned English as my first language, because it doesn't really make sense. It seems like a very hard language to learn. As I've tried to learn other languages, I'm just like, it just doesn't make sense, like why is laugh becoming laughter when it's plural? Why isn't it just laughs? Like, it just doesn't make sense. So again, it's not so much that like they don't speak English, but rather like maybe they do a little bit, or they even have an accent. Like I said, different cultural habits and customs, or even mannerisms too. There's a you know, different places you can go read about making sure people understand you. And I'm going to talk a little bit about that, but other cultures might just, you know, nod and say, okay, okay. And it's less of I understand this and more of I'm acknowledging you said something and I'm still engaged in listening to you, regardless of my comprehension of that. Like that just, you know, is a thing other places might do. So it's good to assume that that's not what's, you know, they're not just on board with you. You can just go over like a big legal document like a lease. So like I said, it's for individuals who don't speak English primarily, or it's not even the first language they grew up speaking. It could be it's reading, speaking, writing, understanding it. It can fall under all those things. And this is a tough thing because the question comes up a lot of, well, do landlords have an obligation to provide translation services, to have a lease that's in, like, say, Arabic? If they, you know, the person who they're renting to, that is their first language. And that's a tough one. I mean, I think my answer would be, it doesn't hurt, but are you legally obligated to? And that would depend. That's a very lawyer, that's a favorite lawyer answer, is when you ask them a yes or no question, they say, it depends. So it depends, first of all, is this a private landlord who receives no federal funding to either build or operate that housing? And that's the first criteria. If they are totally private, they don't receive any funding, like for the housing authority or, you know, in building it, they're not required to legally. So it doesn't matter if this person even understands English or not. I'm under no obligation to provide them any interpretation services or translations if I'm totally a private landlord. However, housing authorities, places that are low income priority housing, those places that receive either assistance, you know, vouchers, are subsidized in some ways by the government, they are required to provide these things. Now, it gets a little difficult because you're like, to everybody? Because like there are languages that I personally, I don't even know they exist, but they're out there. And so it's not that you have to provide this for every single language, but you do have to be able to provide it on a number of different things. Mainly, is this a non-English language that's commonly spoken in the area that you are serving? Spanish is a really, you know, it's a good example. You can know yes or no, like, okay, I don't know if you folks are familiar with Lexington or you're in Lexington, but in the Cardinal Valley area, that has become a, you know, larger concentration of Latinx folks, migrant workers, and so forth. And so Spanish is spoken a lot more there than it is, say, you know, I don't know, somewhere else like Jacobson Park or something like that. So because somebody there who might have public housing might be interacting with folks who speak Spanish primarily, or have a limited English proficiency, they might be obligated to, or they would rather be obligated to provide translations, even have interpreting services or bilingual staff, because of the prevalence or the frequency with which, you know, that language is going to be coming up. And again, it's depending on literally that first factor of whether or not you get federal funding or not. Factor 3 here, though, under whether or not you're supposed to provide the service, the importance of service is a funny criteria because if we're talking about housing, it's pretty important. So yeah, as you can see, the very obvious hint there. And then also the costs versus the resources. Some places have taken initiative in those communities where English is not the only language commonly spoke to hire bilingual folks, or maybe hire people from the communities. There's a lot of translation services, interpreting services that you can use, like especially these days, like video calling and so forth. There's a lot of things you can do that aren't very cost prohibitive. But again, it does depend. But I think the big thing is that if a housing provider receives federal money, and it doesn't apply to Section 8, funny enough, that does not apply to this. What it is really public housing and subsidized housing. That is like there are complexes that aren't associated with the housing authority in Lexington, but they get money from the government to provide low-income housing, but they're kind of private companies. They're not associated with the housing authority, but they're still required to provide these translation services. So, like I said, some of the things that folks can do, companies can do to help out with, folks who just come in. I always tell property managers and landlords, like, just because you're not obligated to do it doesn't mean it's not a good idea to do. And I think that's a thing I've been trying to stress a lot, especially in this COVID-19 era, is that being in good relationship with people will absolutely help you kind of survive together during a time like there's a global pandemic. Kind of taking those extra steps to connect with people, have good relationships with people, work with folks who maybe, aren't able to pay rent, or maybe, the landlord can't afford for somebody to come and make a repair, but maybe the tenant is okay to do it, and they can work out something like that. So again, I always say, like, it's never a bad idea to incorporate these practices in there, even if they're not legally required. So as far as noticing cultural differences, this always is a little tricky for folks, because some people are like, well, I just feel like I can't talk about anything anymore. And that's not true, right? It just depends on how you are in relationship with folks. Somebody who I have established relationship with, if we have that level of comfort that we've kind of engaged in, maybe I will ask them, like, what was it like growing up in Bangalore, in India? And I'm not asking that question because of any perceived difference. I've already got a good relationship with this person. And it's also maybe relevant because we're just talking about our respective childhoods. So again, I think this context matters, and also your intent matters on this. And it's funny, right? Because I said intent doesn't matter back there. But I think in here, not only does your intent matter, but also like why you're doing it and what do you want that information for. And again, most of it says just connect with people, right? But kind of othering somebody or treating them primarily different because they dress differently than what you're used to dressing as, or have a different skin color than you, maybe speak a different language, or have an accent or something like that. My partner has a name that people always comment on, and it's she's grown up with it, and she just often just brushes it off. But people will make a big deal about it, like, oh, that's such a different name. I've never heard that. That's a very interesting name. And different and interesting, depending on who it's coming from. These words can be indexers for, I'm marking you as different. And it's not untrue that it's unusual or not a common name, right? She's the only person I know that has that name. But also, I think there's some fatigue. It's what they call microaggressions that she has around that. I'm just using this as an example of like constantly being reminded you're different. So again, thinking about this, and also just making sure that your relationship exists first before kind of talking about your differences. Using I statements is also a good idea. So that example I just said, my partner, she gets told that her name's interesting or different. Her name's not interesting or different only because of as an intrinsic or natural value. It's just interesting or different because of this person, right? Because they've not encountered it. When really that person could have said, maybe, and it feels differently, like, oh, I've never met somebody with that name. That's really cool. That for some people might change the way that's talked about or heard. And again, it's not going to be a hard and fast rule, but always using I statements is a really good idea when you're talking to folks. And especially in like housing situations where you might be the person acting as like an agent for somebody, and whether you're a landlord or whether you're a service provider, being just using those I statements is just it's a really good practice, and just outside of this as well. Okay, so I'm at the 2 o'clock mark. I'm a little ahead of where I thought I would be at this point. I think it's just because the virtual thing. So I'm going to propose a 10-minute break. And that's so that I can sit down for a couple minutes, drink some water, give myself a break, but also just take care of yourself as well. We will come back I will start promptly at 2:10. So I have 2 o'clock, and it's actually about to become 2:01. I am that meticulous. I'm watching the seconds of my training right now. So we will now come back at 2:11 now that I have talked over that. So at 2:11, I will begin. And yeah, just let me know. And if you have any questions, go ahead and type them into the chat, because when I come back, we're going to have time to talk about it. So if there's something that you wanted to just bring up and maybe haven't yet, we can maybe have a little bit of discussion where actually we talk and you can unmute yourself as well. Okay, so see you all at 2:11. I talked about earlier. Child support could also be one. I know people have a lot of opinions about that, and it's a very broken system. But if somebody is regular child support coming in, and they count that as part of their income, a landlord says like, well, what happens if they stop paying? I can't rent to you if that happens. I don't want that to happen and have to figure out things and so forth. So I'm not going to rent to you because you receive child support. Can't do that. Because again, that's discrimination on the fact that this person, again, disparate impact on more people who happen to be women or parents than folks who are not women and single mothers. Just to kind of stick on that a little bit, I have a job and I'm renting at a place, but there's no, things happen, pandemics happen. I could lose my job, and for unforeseen reason, again, landlord would have to deal with that as well. So this isn't a unique thing that people's income just disappears, but somebody is making an assumption because of the type of income it is. They're making an assumption and projecting that onto what type of person they think this is as well. So again, the wall balls up into a big, nasty thing of discrimination. The two I'm going to talk about the most today, though, are domestic violence and sexual harassment. These are the things that we encounter the most. Domestic violence is definitely a thing that we see regularly. We have unfortunately, a regular clients that we're assisting because they've either in threat of losing housing or have already lost housing because of the fact that they survived domestic violence and it happened at a place that they were renting. So I talked earlier about no criminal activity clauses being in leases, right? Again, with that sort of, it applies to everybody. Everybody's treated the same sort of pretense, except for the fact that criminal activity can sometimes involve police responding or EMTs responding to a domestic violence call. In effect, just what that means is somebody who is in the middle of interpersonal violence called the cops because they probably feared for their life and now are going to get punished by the landlord because the cops arrived. And so not only is this person now probably got to figure out a lot of things for their life, but they also have to worry about losing their housing. And that is a big fair housing problem for me. So other things that kind of go along with that are zero tolerance policies. So again, if the cops are contacted or anything like that, refusing to rent to somebody because maybe their most recent residence was at a domestic violence shelter. I used to supervise the Greenhouse 17 here in Lexington. These are places people live. These are very, they are as authentically their homes as anywhere else. And so to basically decide that as a policy, we're not going to accept people because they're coming from a shelter is very discriminatory and very much a fair housing violation. Because again, there is a projection on what type of person, what kind of tenant they will be based on past experiences or even now their new identity as a survivor of interpersonal violence. Other times, this will be housing providers will try to write it in neutrally and say like, well, we just need references from previous landlords, and that doesn't count. Well, we're here to tell you that definitely counts, and I have been that reference for people because I was the person who saw over the shelter. And I told them like, yeah, they're great, they're really clean. I don't know why you wouldn't rent them. So again, not only is that valid like tenant history, but also there is an assumption that a lot of landlords make too that like if you're coming from a shelter, trouble's just going to follow you. And I don't want that trouble. I have a zero tolerance policy, or this is a crime-free environment. So you just probably are going to create problems for me, and I don't want to rent to you. Got a big problem with that too. So that again are very I say unfortunately because it's unfortunate, it's as common as it is. I'm glad to take these clients and these cases and help them. The only reason it's unfortunate is because it's just so frequent that this happens. The other thing that happens sometimes is, again, maybe landlords are just trying to get ahead and say like, well, I'll rent to you. I understand all this, but I've had other people who were fleeing domestic violence and they just had to break leases early, and so I'm just going to charge you extra deposit to live here because in case you have to break your lease early to move. That's putting a big financial obstacle on somebody because of their experience as a survivor of interpersonal violence. Again, that is a fair housing violation. So the reason domestic violence ends up being a fair housing issue is because disproportionately the folks who are surviving interpersonal violence more often than not are women than they are men. That's not to say that like men don't experience it, and we're talking not just like in hetero situations, but also in same sex or other compositions of relationships. But overall, there is just a higher proportion of women who are going to experience domestic violence and therefore the legal ramifications after it than men are. We've taken cases where there was a male survivor of interpersonal violence, so it's not outside of that realm. But at the same time, this is why we fit this under our fair housing umbrella, is because it in effect becomes discrimination on the basis of somebody's sex. There is a law that was passed in Kentucky, so it made my fair housing job a little easier and kind of moved domestic violence housing issues into kind of what our general landlord-tenant law is. I'm trying to think, it was 2017, 2018, a law was passed at the state level that prohibits a landlord from doing any of these things simply because somebody, while living at the property, experienced domestic violence. The violence was happened to them, and their abuser came to their place or something like that. Or, like I just finished talking about, people who are trying to find housing. The last one here, retaliating against a tenant solely because they have an EPO against somebody. I know that sounds cruel and unusual. I wish I didn't have that in there. I have it in there because it's happened. There's a comment like under VOCA or VAWA, victims are protected. And that does apply mostly to places that get federal funding for their housing. They are good models to follow, but like there are exceptions to that with private housing. Fortunately, though, this law that was passed in Kentucky, like KRS 383, I forget what the sub number is, basically follows all those VAWA things, though. So we do kind of have basically the same protections from VAWA and VOCA as we do in this law now, thankfully. And this was crafted by folks from the Kentucky Coalition Against Domestic Violence. So that's why they use that as a model. This was from folks who work with survivors of interpersonal violence. I'm going to go back to this retaliation thing though, because there was a client I had, we had in our office, and got this note from a landlord. And the landlord said, I'm going to evict you if you don't drop the EPO against your husband, because I know him, he's a nice guy, and I just think this is made up. So you have to decide if you're going to continue to press these charges or, if you want to live there. Like, that's a real thing another human being said to somebody else. And that's just abominable. So yeah, retaliation like that, or leveraging somebody's housing because they have an EPO against a particular person that the housing provider just happens to know, will be a big fair housing violation. We usually, so this law right here, so there's some best practices or things that are, things that are available for landlords to try to help survivors of interpersonal violence. Requesting that the locks be changed is one. I have found that more often than not, most survivors just need to go. The changing of the locks might not be the thing that keeps them safe, because doors can be broken down. But a landlord can maybe obtain, like if it's an apartment complex, a no trespassing order. They have, if they have like a leasing office, they can add that up to the leasing office, and they might not let that person on the property. If the landlord has different units for rent, maybe allowing that person to transfer to one of those units if that person feels like that would be a safe option for them. There's also in this law specific language written around that gives the landlord standing to basically sue for the cost of any damages to the perpetrator, to the abuser of this person, to remove that financial burden from the person who's the survivor. This is probably the most contentious thing because a lot of this is work. This is work for landlords, and a lot of them don't want to do it. But it's also the law. So again, people who are survivors of interpersonal violence who end up getting stuck with like the cost of like a broken door or windows or damage to drywall, these are things that we try to go to the mat for when it comes to making sure they're not held responsible for that, and we'll file fair housing suits if people in essence are basically being penalized because a violent person came, terrorize them, and damage the property as a result, or as a consequence of that. So again, the VAWA guidance is pretty similar to this as well. Somebody had a comment say, I've had landlords not rent to me because I was a single mother and woman. They said I would bring men in. There you go. I mean, again, I believe that. I've heard that, and talking to other folks. And again, there are just people out here, because of the way property rights operate, a lot of people think they literally have license to make up any kind of rules or regulations that they can about the property, regardless of what existing law says they can or cannot do. And again, this person, Office One, who added that to the comment, that's sad to say. That's not uncommon for people to say that. So yeah, Abby's right. That could also be a familial status case as well, because you had children. That they were going to rent to like a single man with children, but not you. There could be some familial status component to that as well. So I know I'm kind of like shopping for work right now, and it seems really gross. But I mentioned this earlier, like if the person who mentioned like the landlord would only rent to married couples or whatever, and I said, if you just don't know who they are, let me know. Same thing applies to you. If you just for whatever reason know the property, if you don't even know the name of the landlord or anything, if you just have any information that identifies where that happened at, I'm glad to investigate that. But not only that, since that is a personal thing that happens to you, residents have a pretty good timeline to file fair housing complaints. So if it's within a year of something happening, we can file a complaint with like a Human Rights Commission, and that's called like administrative hearings, where basically they will decide if it's discrimination or not, and then it might move on to a court. Or you can also, and you have a year from the last event to do that. And then if you want to just skip that and file something in a federal court, you have 2 years from the last act to do that. And something that gets argued a little bit is like, well, when did this stop happening? And we have a pretty liberal definition of that, which is if you're still living with the consequences of it, it's still happening. So again, feel free to confidentially reach out to me after this. Like I said, my contact information will be shared at the end of this PowerPoint. If you want. I also understand, the importance of being able to just move on as well. But yeah, this is, like I said, this happens unfortunately very often in our states. I am adding the contact information for our state coalition against domestic violence, just because they have managed all of these shelters all over the state, and depending on where you are, I just think it's a good idea to know which shelter your region is going to, which shelter would be the region for like your AmeriCorps site, because they can be good resources. Surprisingly too, like if you contact a place, let's say you're in Leslie County and LPLP Safe House is your place, they might be full, but they could probably contact, say, Greenhouse 17 in Lexington, and Greenhouse 17 has vacancies, like beds open, that is. If the person you're working with is okay with relocating, this coalition and the shelters might help to organize transporting this person to a shelter in a different region. So it's good to know which ones are out there. When I worked at Greenhouse 17, I had somebody in one day drive all the way to Marshall County, pick up somebody and bring them back to our shelter in one day. So again, some of these shelters are willing to like kind of accept people even if they're not in their region, but it's good to just kind of have an understanding of where they all are and which one should be at least the first point of contact for you. This can be found on that website, kcadv.org. They've updated the site a couple of times. I'm not sure where it resides right now, but it's on there. I mean, you can also just call them too. Like I said, they're a great resource. So the other big thing that happens with sexual harassment, or sorry, discrimination on the basis of sex is, or the basis of sex is that sexual harassment happens. It happens between neighbors. It happens between landlords and tenants. There are some really awful things that have happened to clients of ours because they were women and they were renting from a man. And I'm not saying that this is not able to happen between two men or a woman landlord and a male landlord, but like this more often than not, the scenario that happens is it's a male landlord and it's a female woman identified tenant. So the first one, the quid pro quo, that's like some legal language, some Latin, but basically that means when somebody who's a housing provider or a landlord approaches a tenant and tries to leverage some kind of service in exchange for a sex act or, you know, sexting photos or something like that, something that coerces that person to participate in some sexual activity with them. I don't even want to, I don't like to say participate because there's some sort of consent implied in that. So again, just coerce that person into sexual activity with them. This can be like a case I had a couple of years ago where a landlord had a habit of coming to a person's, a woman's, this was a male landlord, coming to a woman's apartment and trying to coerce her into sexual activity in exchange for a $50 rent deduction. She actually, it was happening so much, one time she had the presence of mind to actually set up a recorder. And so she actually got this on recording, and it's now a case that's being tried at the Department of Justice at the federal level. And this landlord might, depending on the outcome, as a result of this case that we initiated. So again, this, it sounds like, how can that happen? That people actually do that? Yes, they do. It could be less direct than that. It might be, we've had cases where the property manager just continued to text somebody, or maybe found a tenant on Tinder and continued to send them messages, and his unwanted advances kind of started to feel like harassment. And as soon as like that starts to happen, somebody's sense of safety in a place that they live kind of deteriorates, right? Because basically a tenant, like I said, more than likely a woman might have said no, and that denial or like refusal of those advances, you don't know how that's going to play out. That person also has a key to your place and is employed by the place that you rent from, and so there's a lot of leverage and loss of power involved in that. So again, that creates a hostile environment for some folks. That can also just, maybe it's not like unwanted advances, but maybe it's just like jokes or gestures and stuff like that. Maybe, you know, it could be something very lewd, you know, or exposing yourself to somebody, to a tenant. Like, again, these are things that have happened, and, you know, they're very serious fair housing violations. Let me see. The last thing too, with regard to remarks, these two things, especially the hostile environment, actually, I'm going to focus more on that one. The hostile environment can happen not only between a tenant and the person they rent from, or somebody who works for the place they rent from, but it can also happen between neighbors too. Again, the pushback I get sometimes is like, well, how are you supposed to meet people? And how are you supposed to date people? And it's just like, there's nothing that says, you know, flirting is prohibited, but taking no as no is the thing, right? When that becomes something that is unreciprocated and has been, you know, somebody has told you they don't want that attention, that's when it kind of starts to step into like not just sexual harassment, but stalking as well. And back when the law that I mentioned was passed in Kentucky back in 2017 or wherever in that around that area when it was passed, there was also an inclusion here to create something called an interpersonal protective order. And what that does is it allows folks who have not been in a dating or romantic relationship to file a protective order against somebody who's still pursuing them and is, you know, and it's basically stalking. It's gone beyond just unwanted attention, and now it's like hostility and scariness. I've been parts of conversation where like, well, you can just file that against anybody, can't you? And I'm, no, actually, this is the criteria to meet this is manyfold, and it's not actually given out very often. In fact, I think it could be probably issued more, but the criteria is so specific that it is a thing that's not maybe people who should have it or don't get it. So again, but it is a thing that does exist, and it is a thing that is available. There is actually no. There's some information on KCADV's website about how to obtain this, and they're also really good advocates for figuring out, you know, does this qualify? Is this worth pursuing? All right, I'm gonna mute myself for a second. You can go ahead and start reading this. Just muting myself so you don't hear me glug some water for a second. All right, so you've probably been reading this. Morgan recently moved into Unit B1. James, a longtime tenant who lives in B5, notices his new neighbor and tries to befriend Morgan. Morgan and James find they have a few things in common, so they hang out every now and then, get to know each other, and watch college sports together. James expresses his interest in being more than just friends with Morgan, but Morgan rejects James's advances. So despite the rejection, though, James continues to pursue Morgan by texting Morgan sexual statements, posting inappropriate comments on Morgan's Facebook page, and even going out of his way to bump into Morgan in the hallway. So this is whoops, sorry. All right, that's my cue for the next slide. So let's say Morgan goes to the office. This would be worded for like, you know, you were a landlord, but let's say Morgan just goes to the office to the landlord to submit a complaint. What do you think is the best response for a landlord in this scenario? You can just chat in A, B, C, or D. A, tell Morgan to ignore James because James will probably stop after realizing his advances aren't going anywhere. Tell Morgan to call the police next time James does something. Send James a 14-day notice reminding him of your community's harassment policy, or ask Morgan to resolve the issue with James because you prefer tenants to work out their problems on their own. So I'm seeing some answers in the chat, and so far you all agree with me that it would be C. Send James a 14-day notice reminding him of the community's harassment policy. This hinges on the fact that the community, the property manager would even have an anti-harassment policy. That was one thing that we always push on people. We have even helped write them for people just because they should be there for this specific reason. Referring to your chat again, I want to know from you, does it matter if Morgan is a man or a woman? Everybody's saying no. I'm glad, because the advances are unwanted. You're right, Abby. Yeah, this would apply whether it was like people of the same sex, or whether it was of different sexes, or, you know, or other gender presentations or identities. This is unwanted romantic or sexual advances that have gone too far. And yeah, it doesn't matter what the identities of Morgan are. So just to kind of talk a little bit, telling Morgan to ignore it as exactly what I just said earlier in the first half of this, what we tell landlords not to do, because this is about somebody's identity that is protected under the Fair Housing Act. Telling Morgan to call the police the next time James does something, landlords tell this to people. I discourage it, one, because that seems like overkill. Also, it kind of passes the buck from the landlord. Also, we have no idea if Morgan has anything to risk by calling the police. It could be undocumented. They could be a survivor of domestic or interpersonal violence. They could be in recovery. We don't know that much. So again, that's not always the best option for somebody to do in this situation. And then, yeah, okay. Thought I had something else to say. I don't. That's it. So before I go into this, I just want to say that I think maintenance workers get picked on a lot by tenants, sometimes by us, and sometimes I think they're also in one of the most vulnerable situations when it comes to like rentals, because they are going into people's houses or homes. They are, I don't know how you all, but I don't like anybody coming into my home that I don't really know well. So I'm always kind of, I've always felt weird when maintenance people come over to the place I rent. So again, I think there's, I extend this courtesy and this sympathy to my maintenance people, because, they just are in a, they have to go into places where like leasing agents or other landlords maybe don't have to. So it's a tough thing to have to go into somebody's home, because you don't know what to expect. I'm gonna answer this question first before we do it. Hunter asks, if the landlord says to call the police, then prosecutes the person for drawing criminal activity, that is something your office would pick up, correct? Correct. We would. Yeah, let me know if you need more information than that, but yeah, that's a thing I don't like. So Vic has been on the maintenance staff of a place for years without incident. Again, this is worded kind of from the perspective of like if you're the landlord, but for the purpose of this, we'll just kind of make it more neutral. Monday morning, a female tenant races into the leasing office complaining of Vic's inappropriate behavior when he came into the unit to fix a leaky faucet Friday afternoon. The landlord speaks with Vic and states that, Vic states that he just made small talk with the tenant, complimented their appearance, and fixed the faucet and then left. Vic adds, though, that he gave the tenant his personal cell phone should she continue to have a problem with the faucet over the weekend. So how should a landlord resolve this situation? You can add your answer A, B, C, or D, or E in the chat if you want to participate, play it along at home. Tell the tenant that she misunderstood the situation because Vic has never had a complaint submitted about him. B, document the incident and remind Vic about maintaining professional boundaries. C, ask the tenant if she was wearing something or acted in some ways that gave Vic the wrong impression. D, do nothing because it was a one-time incident. I rarely advise people to do nothing in these situations. Or fire Vic because he's apparently a fair housing liability. Everybody that I see is saying B, and that is what I would do. Again, we always tell folks, I tell tenants this, and I tell landlords this too, document everything, every interaction you have in these sorts of situations, because at this point, I don't know if this is a pattern of practice. I don't know if this is something that's going to be a bigger problem. As a fair housing liability thing, if I'm a landlord, I definitely want to at least document this, because if this escalates or Vic continues to show this sort of behavior towards other tenants, I don't know that it's a firing offense, but we might have to have a little come to Jesus talk about this is not the place to go try out the Plenty of Fish First Life adventure. So again, B would be the response. But yeah, always kind of gaslighting tenants and telling them that it's probably nothing is just not a thing. We try to get our people that we train not to do that, and to always, take what they say with seriousness. Unfailingly, there's always landlords who come up and say, what about the other way around? And I have talked to maintenance guys who've said they've gone into a place and they've gone in and it was a man who was a maintenance worker and gone in, it was a female tenant and was like, just kind of looks a little more prepared than just for some maintenance on the apartment, if you know what I mean. It might have like lingerie on. I've had maintenance guys tell me they've gone in and the tenant's been naked, kind of in a very sultry or seductive way. So I will say, I do think that happens. I also think that that sort of non-harassment policy has to apply to staff as well when it comes to tenants. Doing that towards their staff as well. Maybe a 14-day notice or something like that, or just reminding that tenant, like, this is maybe not the most appropriate way to welcome the maintenance person into your office or into your apartment. So yeah, I just mentioned that because it always comes up in trainings when I do this with landlords, and it just does. And people are people, and sometimes people get really excited about the hunky maintenance worker. But not said, this maintenance worker also has a right to work in a safe place without sexual harassment or unwanted advances. So sexual orientation and gender identity, like I said, previously had just been limited to places that had fairness ordinances, but now we have this brand new Supreme Court decision that's going to actually allow places like my office to pursue discrimination complaints wherever in Kentucky it happens. And it's not just dependent on where the place where the tenant lives and whether or not they have a fairness ordinance. This is actually the map of where it was before. You had to live in one of these 18 places in order to have legal standing to say that you wanted to, you felt like you were treated differently, denied housing or something like that, or harassed. And we would still take those cases even if you lived outside of these places. It's not like we just say like, sorry about you. We would still take them. It was just harder for us to pursue them. Now it's less hard and it's less difficult for us to do that because this whole state is now just one big star instead of it just being 18 discrete stars. So luckily, yeah, that has opened up a lot of protections for folks because you can see it's pretty much concentrated in most of the metropolitan areas, central Kentucky around Lexington, northern Kentucky outside of Cincinnati, and then number one is Louisville, and they were the first one to pass such an ordinance. So yeah, while a large part of Kentucky's population might have been protected, it really left a lot of rural people just really vulnerable to a lot of really awful housing practices. I think about this a lot with regard to what we talked about earlier when it comes to race or skin color, or, people's, religious practice, if you can identify that based on like what they're wearing or something like that. Is it a landlord tenant issue, or it's like, was this person treated differently because they identify as gay? Or is it just something that is maybe just a financial thing? This person who identifies as gay maybe feels like they paid this late fee and has a receipt for it and the landlord overlooked it. And it's just a mistake, as opposed to like a landlord leaving a note on a tenant's car that says, the landlord knows the tenant to be gay, and landlord leaves a note on the car that says, "Get out AIDS." It's a fair housing issue. That's not a quiz question, but not only is that a fair housing issue, that's something that happened here in Lexington once upon a time, not that long ago. So there is still a lot of hostile attention towards folks who are, queer identified, gay, lesbian, or trans. But they might also have standing for more than just the discrimination on the basis of their sexual orientation or gender identity. Actually, under fair housing law, having a positive diagnosis of HIV or AIDS is actually considered a disability. The reason for that, and this goes back to that people first kind of insider outsider identification thing, because the people I know who have a positive diagnosis, I'd never say that they have a disability. I've never heard them talk about themselves as if they have a disability, but under fair housing law, it is considered a disability. And the reason for that is because there was a lot of really intense activism in the 90s to try to protect folks who had a positive diagnosis of HIV or AIDS from being denied housing, because housing and the health outcomes of folks with this diagnosis were so intrinsically linked that like homeless folks who had a positive diagnosis just did so much worse. I mean, they virtually, and a lot of, to put it cruelly, it was a death sentence. And so a lot of work was done to actually include this in the fair housing law and make this like something that is covered. And so this is not just proof of a diagnosis, right? It could be the perception of that as well. That example I just added a second ago about the landlord leaving the note on somebody's car and said, "Get out AIDS." That person didn't have a positive diagnosis of HIV or AIDS, but they had some other health, like the flu or something like that, right? And had mentioned that to the landlord. And the landlord just took that to mean that they must have AIDS and they had to get out. And so it was just that landlord's assumption or presumption that because this person is, they identified as gay, because this person is gay, if they're sick, they must have AIDS. Can't have that. And so that's how that escalated. This also can be included under the umbrella of like discrimination on the basis of somebody's sex or gender presentation. If for some reason somebody comes and maybe they are, non-binary and feel like they've been treated differently than like somebody because of somebody who very clearly identifies as like a femme or a woman, or somebody who identifies as masculine, but somebody who might be like not, in that binary and a little more expansive. Somebody who feels like they might have been treated differently or denied housing because of that, that's also maybe grounds for a discrimination complaint and could be a violation of fair housing law. And like I said, harassment issues. So again, I'm throwing this slide up. You've seen this slide. I showed it like an hour ago, but this slide basically with regard to, is it just a noise issue that like, Lisa listens to music loud and Dave likes the quiet at a certain time? Or is Lisa harassing Dave because, or playing the music loudly and also, directing some really nasty language at Dave because Lisa thinks Dave is gender expansive or non-conforming? So again, kind of deciding where that is, and it's a hard burden for somebody to try to collect evidence about, because people say stuff. We all have cameras all, in our pocket all the time, and it's a little easier to record stuff and do that. But at the same time, it is not a thing that like everybody's just prepared to do, right? To just record the statement because I think I'm about to be hate crimed or slurred or something like that. So sometimes it requires a bit of a lot of investigation on behalf of our office to be able to determine like if that's was in fact, we could legally prove that that was identity-based discrimination or harassment. And sometimes, even though I believe that this happened to folks, sometimes we don't have enough evidence to do it, and that sucks. And that's not a fault of tenants. It's certainly not a fault of theirs. It's just the legal system requires a lot of proof, and sometimes we just aren't able to get it together. So familial status, I've talked about, we've had some examples with this and stuff. It's just the presence of children under the age of 18. Stating a preference of folks that you prefer, a landlord prefers to rent to people who don't have kids. Sometimes it's a little less obvious, landlords might say, it's an old property, there's lead paint, kids shouldn't live there. And they might be trying to look out for somebody who's a parent and going to have the kids living with them. But that's, again, a decision a housing provider cannot make on behalf or for a prospective tenant. It might seem a little Mad Max undertone-y that like, oh yeah, we're just going to let the kids in there and eat lead paint or whatever. And the landlord can't really say, I'm not going to rent to you because of that risk or not. They just have to treat them as if they didn't have kids. There's a weird exception that happens. So there are like senior living communities designated for seniors. Sometimes it's 55 and over. Other places it might be 62 and over. And these are places where it actually is a legal criteria to only offer to rent to people who are at or above that age limit. But sometimes maybe a grandparent has custody of a kid because, the kid's parents might be incarcerated, or maybe they've died, maybe they've just effed off and just didn't, couldn't handle parenthood and just left the kid. And, we don't know, basically. But basically, there are situations where if a person who is got custody of a grandchild or somebody that lives in one of those senior living communities, the community is maybe under an obligation to allow that person to have that kid. I say maybe, it would be a fair housing violation not to let them continue to live there simply because they obtained custody of their grandchild. Let me see here. Other things that come up. Oh, somebody's got to leave at 3 today. Okay, that's okay. Caitlin, we're until 4, right? You said 1 to 4. Is that correct? Or Holly? Yep. Okay, cool. Second guessing myself there for a moment. Anyways, other things that come up, it doesn't have to be like people that are biologically related from between parents and kids or grandparents and kids. It could be somebody who fosters kids. It could be somebody who is in the process of adopting kids, and those kids just are living with them. Maybe are in the foster system and are going to be moving out of it. Sometimes it could just be kids who are visiting. And a landlord might just be like, sorry, there's not supposed to be any kids there. So here's the thing with that. So it's one thing that landlords can say they don't want any unauthorized guests or any unauthorized occupants. Let's say that. Because I think legally, our attorney would argue that landlords do have a legal right to know who is living in a property that they own. But that language I just said, there's not supposed to be any kids there. That is very different than saying there's not supposed to be anyone else living there. Because by saying that there's not supposed to be any kids there, I have maybe unintentionally just said, I wouldn't mind if it was other adults that were living there, but not kids. So language becomes very important in these sorts of things. And language is also really wild to me because of people's willingness to put it in writing, whether it's texts or emails or just scribbled notes that were left at the door. I actually had to work out something with a housing authority a couple of years ago because they had some community rules. And in those rules, it said kids can't leave their bicycles in the front yard. And I was like, well, what about me? What about the adults? Can they do that? And so because it named kids and equated or connected kids to an issue that would be considered a broken rule if somebody did it, we were able to argue that like that's actually maybe targeting, that language targets people with kids or puts like some unwanted or unnecessary concern on people with kids. And so the fix, we didn't, sue anybody out of a job or anything, but we just helped them revise that. So like, just leave the kid part out of it. Say, just don't leave your bicycles in the front yard. And it just includes everybody. So again, sometimes that language, it seems like we're being picky, but anybody who's had experiences, when language has they felt discouraged them from doing something or pursuing something, I think it makes a big difference in how things are worded. So that's why I talked at the very beginning of this about how we word some things, even as we talk to and about other people. It has impact. So I actually want to just check in if anybody has any questions, because we're about to go into a big section and it has a lot of, usually elicits a lot of questions, and it is about disability. But I want to check in with anybody to see if you have questions about something that I just talked about or talked about in the first hour. Maybe, you know, ask me questions about what's happening with you if you've got an issue. Maybe I can help you with that. But yeah, I just want to hold some space right now, just because, like I said, I've got a little extra time. If anybody wants to ask a question about any of the material or further information about things I mentioned, and I'm going to take this risk and ask folks to just come on mic and say something. And if you do, feel free to just ask me. I'm going to just, you know, like I said, I'll wait like 15, 20 seconds. And if nobody does, we'll just move on, okay? All right. Everybody's got it. I'm taking that silence as a affirmative understanding that this stuff is just getting into your bones. I've also just been talking to myself for too long, so this last half hour might get weird. I'm glad that you can't wait to share it. This is, like I said, this is stuff that it always helps just repeat and kind of share with everybody. And it's also useful in your personal life too. My friend circle know me as the housing guy and will just ask me questions about landlord-tenant stuff, you know, fair housing stuff, how to help people. Is this okay if a landlord does that? It's really awesome to be able to be that resource for your community, whether it's your personal community, your work community, because it's knowledge that people need. It's knowledge that people, I think, oftentimes don't know where to get. And so just kind of identifying yourself, you know, as that person, they're like, yeah, I did this, I learned this, or whatever. You know, that can really help out folks that you don't even know. Will value that information. So disability was, whoops. Every time I click over, I lose my advanced arrow, and I still have lost it. Disability applies to virtually all housing. The Fair Housing Act applies to virtually all housing. I think there might be some weird legal gray area with houseboats, private places. Like if I just rent a room out of a place I live, there's some gray area for that. There are some things that definitely still apply and some things that might not. There is actually 3 laws that apply to housing when it comes to disability. And it depends on how many of those laws apply, depend on where you get your funding and when it was built. So the Fair Housing Act, like I said, applies to virtually everywhere. There's something called the 1973 Rehabilitation Act. And what that says is that if you receive federal money, you are, one, going to be responsible for any modifications that tenant might need, regardless of when it was built. Maybe that housing complex, the apartment complex under the Housing Authority was built in the 80s before the Americans with Disability Act. But if somebody moves in and they will be able to live there if there was like a grab bar in the bathroom or ramp. Because the place receives federal money, they're going to have to make that modification for that person so that that person can live there. And the legal term is use and enjoy the dwelling, as somebody without that disability would be able to use and enjoy that dwelling. You'll see here the caveat is it doesn't apply to Section 8s or any other vouchers. Those are still considered private landlords. And so it wouldn't apply to that, but public housing places, places that offer subsidized rent, like basically like the place-based rather than like voucher-based, if that makes sense. And then there's the Americans with Disabilities Act. I think with the it applies to public structures and not actually the inside of a dwelling. But a lot of apartment complexes have public places. There might be a playground, there might be a pool, there's probably a leasing office, there's a laundry room. There are common areas that would be considered public that are covered under the Americans with Disability Act, but also the Fair Housing Act. So if I'm building an apartment complex, I might not have to put grab bars in all the apartments, but I definitely have to make sure that the laundry room is accessible and is accessible to, say, somebody with a 36-inch wide wheelchair, because they need to be able to use that just like anybody who doesn't use that wheelchair. So any new place that's built after 1991 generally has to be not only ADA compliant, but also fair housing compliant. The frustration with that is it only applies to properties that were built after 1991. And most of this country was built before 1991. So more than likely, the ADA doesn't apply to existing structures, all those ones that have been existing before then. And I can't really say whether or not it applies to places that are modified or buildings that have been rehabbed. That's just a legal question, I don't know. But I do know that the Fair Housing Act does apply to those places. Like there's a building downtown here in Lexington where they just kind of hollowed it out and built condos. Our office does what they call accessibility surveys. So new construction sites that are going to be offering housing, we'll go in there and got a tape measure and a laser measure and other stuff. And we will measure like how high is the thermostat. Could somebody with a wheelchair reach that? Where are the outlets? How many curb cuts are there in the parking lot? In addition to how many accessible parking places are there that are reserved for people who need them? So we will go into places and we will find out all that stuff. And it kind of becomes some real meticulous measurements of like how accessible is this place. The oven door has to open and have enough space behind it to be able to, again, put a wheelchair behind it. It has to be, if it's built now, you know, like currently, it has to follow these fair housing guidances. But that's really about construction and stuff. And I don't know if any of your sites are going to be involved with design and construction of new homes that people are going to be living in. And like it's single family homes is a little different, because if I'm just building a house, I can do whatever I want to it if I'm going to be the one living in it. If I'm going to be renting it out to a place, there's probably more restrictions about how these sorts of things have to be constructed. If I'm just rehabbing a home and flipping it, again, it's as if like I own it, and nobody lives in it. Whoever buys it is, you know, going to move into it. That is less regulated. So disability can be something that's physical or emotional. I've kind of started using visible or non-visible instead of physical or mental. Just kind of, you know, that's the language I've picked up from disability activists, and I kind of like that a little better because I think it's broader and it's also, I think, more specific than just mental health disorders. I think that's got a stigma to it. So just, you know, non-visible disorders. Those might be cancer. It might be somebody who has chronic depression, is on the autism spectrum disorder, has diabetes. That could be somebody, like I said, who has a positive diagnosis of HIV or AIDS. Might be somebody who has epilepsy. In addition to people who need assistive technology because of limited hearing, their mobility, or visual access or acuity. So again, it could be things that are immediately observable, or it could be things that you would never know about unless you interacted with that person and they told you about it. And all of these things are considered, and this is not an exhaustive list. These are just examples to kind of get you thinking. And so maybe you're like, I wonder if this is a disability. If it's a diagnosis, it might be. So yeah, we usually advise folks, housing providers, so like landlords, you just can't ask a tenant, hey, do you have a disability? Sometimes actually what I hear is like, are you disabled? And again, that's that people first language, or, you know, centering people instead of like the thing that has that is an identity of theirs, or asking how bad people are, how bad someone's disability might be. Sometimes too, landlords have dismissed people's disabilities because they feel like somebody who has, the only people that have legitimate disabilities are people who receive disability income. And I have never been on disability income. I don't know if any of you have ever known anybody who's gone through that process, but it is really hard and takes a long time to get that. So there's a lot of reasons why somebody with a disability might not get disability income. And a lot of people with disabilities are still able to work too. So, you know, whether medication management, therapy, or other accommodations. So just because someone has a disability doesn't mean that they're, you know, they must be on disability income or receive that income. But there are some people who feel like those are the only legit disabilities. And if you don't get disability income, you must be malingering or making it up. Unsurprising, those are the cases that usually come to us. I don't know if I mentioned this or not. So this is like the ninth thing I've talked about that's protected under fair housing law. Disability is actually the #1 most frequently reported complaints that we get as far as discrimination goes. Could speculate why for certain reasons. It could be there is this less stigma around people with their mental health, and if they have a diagnosis around that. There's just more awareness, I think, about non-visible disabilities. As I mentioned, there are also a lot of landlords who have never been through a training like this. I told this to Abby and Terrell, our two AmeriCorps folks who are working with us, like, you know, after this, I guarantee you're going to know more about housing law than probably every landlord you've ever rented from. Because that's just how unregulated it is. And that's just how easy it is just to call yourself a landlord and start doing stuff. Like, you have so much more information than people you probably rent from right now. So that's really powerful stuff. And, you know, now, you know, to be able to use that and help that and share that with other people is a pretty cool thing to offer folks. So yeah, those are things you can ask. You can ask specific questions depending on very, very specific housing. There's a big pool of government money. It's called Housing Opportunities with People with AIDS, or for people with AIDS. It was 90s language. It's very outdated, kind of like the fair housing law has outdated language too, because it still uses outdated terms like handicapped and things like that. But HOPWA, like I said, the Housing Opportunities for People with AIDS, that is money that agencies or housing providers can get that is very specific to providing housing for people with a positive diagnosis of HIV or AIDS. So it is allowed in those circumstances. Like if I have a group home for folks, and that criteria is that you have to have a positive diagnosis for that, I am allowed to ask that because that's actually a term of the money that I got in order to just do that housing. Also, if you offer a place that has that only offers like accessible units, or maybe it doesn't only offer accessible units, but it has a few, right? And somebody requests it, there is some interest in trying to make sure that those accessible units go to folks who need the increased accessibility. Ideally, it'd be awesome if we had this thing called universal design. So every apartment complex and every house was built universally to accommodate a design that, or a design with a design that accommodates for people to be able to use it of any ability or disability. That's not the case. So there are some reserved units that are considered accessible. And so if somebody requests that, that is within a housing provider's right to ask for, you know, why do you need this place? Why do you need this accessible unit? You know, the question on the right about whether you're currently misusing or abusing a controlled substance, that is in there. And, you know, we've gotten that question a lot because it seems really nosy. And I often, while it is legal that you can do that, I don't trust anybody to actually do that the right way. So you know, it's in there because you can ask if somebody has a disability. And if they say, you know, they're in recovery, and you can ask whether or not they're currently using. Legally, again, it might be, but like, just because you can do something doesn't mean you should, for one. But also, I just don't trust the process enough that somebody would still be treated as if somebody who answered no, I am not in recovery. So again, that is a question I actually discourage a lot of folks who are housing providers from asking, even though again, legally they are allowed to do it. I just think it can open a problem door for a lot of other things. And then asking whether or not somebody meets the requirements for tenancy. So like if somebody comes in and they're using a walker, is asking them like, oh, how will you pay for this? It's one thing to have like income requirements, or you have to verify your employment, because that's kind of across the board. Many of you maybe have come across places that want you to make like 3 times the amount of monthly rent. And those are fair things to ask, but when you're only asking that to people because of a visible disability or because they've disclosed a non-visible disability, depending on the outcome of that application, that could be grounds of discrimination if that landlord just tried to say, oh, well, I didn't think they would be able to afford it because of their disability, and I just chose not to rent to them. That's not okay to do. So here is a scenario. There's an elderly tenant who lives alone in one of apartment complexes units. She seems to be having some memory problems and has some difficulty taking care of her daily needs. Her neighbors come to the landlord and tell them that they're worried about her. I'm not sure if she's taking proper care of her home. And to the landlord's knowledge, it doesn't appear that they've got any family to help her. So, open question, what should you do? That's a tough one. That happens a lot. There are a lot of older residents, older adults who are renters. And this is a situation that comes up, especially, there's been studies that have documented isolation kind of continuing isolation increasing for older adults. Maybe they don't have family, or they had family and they're not on good terms with them. We usually advise folks to tread very carefully with this. Now, if you're a service provider, your limits or ability to help them is very different. In a lot of the cases that you all are going to be working in, it's going to be different. But with a landlord, if you come across a landlord who's like, well, we just had to evict her because she was just being really weird and wouldn't have a shower, like that's somebody who, one, is probably going to be homeless, and if they are in that kind of situation where some of their daily living tasks are falling apart, like that homelessness could be a death sentence for somebody like that. So we do tell landlords to tread very carefully. Here's the thing too, like the law says you can't, ask people if they're okay, or, and people are like, well, what if I try to talk to them and connect them to services and stuff? And, it is one of those things where it might be a case-by-case basis, but like I'm never going to file a fair housing complaint because a landlord was trying to help somebody stay in their home. Well, I don't want to say never, right? Because I'm not going to say that for a landlord who's sexually harassing or coercing somebody to do things they don't want to do to stay in their home. I'm not going to do that, right? So I don't want to say never. But in this situation, when it's clear that the goal is to get them connected to some stuff, to help them stay there, I'm more willing to work with those landlords than the ones that would say like they just aren't fit to live here. So there's 2 different components of fair housing law when it comes to disability. One of them is reasonable accommodations, and one of them is reasonable modifications. The first one I'm going to talk about is accommodations. So these are really when a policy there needs to be an exception for a person because the rules just might not be allowing that person to live or have that opportunity to live into a place. So one example might be like somebody who, let's say, you live in an apartment complex, places aren't assigned, and this is kind of parking's first come, first serve. That usually works until, somebody that maybe just can't go a full distance because they park in the back and they always get home from work late, but their walker just takes them, and they've got some difficulty getting all the way across the parking lot, and it would really help them out to have a reserved parking place nearer to their apartment, that's when we can make an accommodation request, basically saying like, look, I know that this is your policy, but because of this person's disability, they need an accommodation to around that policy so that they can actually live here, you know, enjoyably and without any kind of undue stress that would be caused otherwise without this. And you know, when there are accommodations, sometimes it is legal and maybe even encouraged for landlords to request documentation for that if that disability is not immediately visible. So it's one thing if somebody just sees me strutting across the parking lot, seemingly not having no problem doing that, and I request a reserved parking place versus somebody who you see using a walker or a wheelchair going across the parking lot. It'd be okay for them to ask me for that disability documentation, but it wouldn't be for the person who's using the wheelchair, because again, they just want to make sure that it is a reasonable request and it's actually not being manipulated in any kind of way. Not that people do that, because I feel like, you know, if people need accommodations, they're asking for a reason. And this, you know, again, legally landlords are allowed to ask for those. It has to be reasonable. That's a weird legal term, reasonable. So it's reasonable to ask for one reserved parking place in front of your unit so that you don't have to park really far away and walk to your unit. It might not be reasonable to request 5 different places that only you can park in when you only have one car. And yeah, then you might have to really have a documentation that describes why you need 5 places, because it's probably not going to be considered reasonable under fair housing law. And like I said, it might include a dwelling, like the place that the person actually lives in, but it might actually include some public places like the laundry room. Maybe, you know, well, I don't know about the laundry room, but maybe like the public places like the, I just say laundry room because I can't think of a fast example, but the one I just gave you about the parking lot, that's a public place. That's where the accommodation might apply for that, even though the person doesn't live in the parking lot. They live in an apartment next to the parking lot. So they can be made, these requests can be made on behalf of a tenant or by the tenant themselves. You might be working with folks and you might be able to make that request on behalf of them. Our office makes these requests on behalf of our clients all the time. It can be made anytime. It doesn't have to be made before somebody moves in. It doesn't have to be made after they've lived there for a certain amount of time. It can be made anytime. But it must be related to somebody's disability, right? Like if I live on the, well, I don't know. Should have examples for this, I don't. But it has to be related to the person's disability. So like if I have visual, just limited access, you know, seeing things, but what I want is, I'm just not doing a good job coming up with this on my own. And I'm not going to try to make it up because I don't want to make up or say something that's actually very inappropriate, because that's sometimes what happens when you just are trying to do something unprepared and on the fly. Anyways, it has to be related to somebody's disability. Proper documentation may be required if that disability is not visible immediately by somebody. And landlords, we always tell folks, don't just say no if you think it's unreasonable. Like, try to get some information before. We call that an interactive process, because once a landlord has said no, that kind of opens up that tenant or prospective tenant to some standing to file a fair housing complaint. So again, we always tell people, like, you need to have more information before you say no to some of these things. So these are some examples. Landlord lets tenant out of a lease penalty free after a tenant gets into an accident and is medically deemed to have a disability because the unit is no longer accessible to a unit. So yeah, that's maybe an example. That I'm glad I waited till the next slide. So maybe I live on the 2nd floor, nothing's happened to me, or maybe something has happened to me. Maybe I've become epileptic, right? And I just, I want out of my lease. But you know, living on the 2nd floor isn't related to my disability itself. I just, you know, I just don't want to be on the 2nd floor anymore. And again, it's not related to me being epileptic. That's a little bit different than if somebody who is in an accident and maybe loses mobility with a leg or even loses an appendage, and therefore they just physically can't get up the steps safely, and they need to be, allowed out of their lease. That is related to their disability, whereas the person who's epileptic, like, it might be harder to prove why that is related to their disability. I'm not saying it can't be, but it's easier to kind of put those connections in place than it would be with somebody who has epilepsy. And again, I'm not saying that there wouldn't be a reason why somebody would want to live on the second floor with epilepsy. Just again, as an example. Yeah. So modifications are the second one that come up when folks who have a disability are living in places. So accommodations really pertain to rules. Modifications pertain to the physical place that they live in. So think about it this way. An accommodation is getting an assigned parking place, right? Nothing structurally had to change about the parking place, about the apartment building, or anything like that. A modification might be that I've got an assigned parking place, so that's not the problem. The problem is I need a curb cut. Those kind of rampy sort of things that make the curb and the sidewalk flush with the parking lot. I might need a curb cut made so that I can just get up to the sidewalk with my walker or wheelchair easily, than having to either get out, lift it up, or something really other that just is super difficult to do. So again, modification would be changing the structure, like I said, the sidewalk of that, or sometimes it could be putting grab bars or rails into stairwells, into like a bathroom or something like that. So it can, like I said, it can be anywhere. It can be inside, it can be outside. And the thing with this is that modification, if it's related to the disability, if it's reasonable, it has to be, the landlord has to allow it. They don't always have to pay for it. The reason the landlord would have to pay for it is because they receive federal money. It's kind of like with interpreting and translation services. If you receive federal funding to offer this housing to people, the cost to do that curb cut, put those rails in, or anything like that, will be on the landlord. If I'm just a private landlord, though, like I said, I still have to allow it, but I don't have to pay for it. The tenant has to pay for it. Not only that, the tenant might actually have to give me money to put into a security deposit so that when the tenant moves out, I have the funds to restore that property to the pre-modification state that it was in before this tenant changed it. There's a big, it is a financial burden on folks. And there are services in cities like Lexington and Louisville and maybe some other places that, maybe will assist with installing a wheelchair ramp for folks who need it at a place like this, because it can be expensive, and it can be even more expensive to have to dismantle that when you move out. So again, a landlord might have to allow it, but they don't have to pay for it if they're just a completely private landlord. And so this also has to, like I said, it can be made, sorry, restarting that sentence. The person has to live in the unit. So it might not apply to somebody who is a guest of a person who doesn't need that modification. Now, I say maybe because it's that lawyer answer of it depends. And I don't know, without learning more, like, is this, somebody who's living with this person but isn't on the lease, so there's always room that maybe the modification should be allowed, even though the person who is requesting it isn't on the lease. Like I said, a deposit may be required to restore the property. And again, like the accommodation, it can be made anytime. Something might have changed in that person's life that has made it necessary for them to have a rail up the 3 steps that go to their apartments, or they need a grab bar or some kind of other barrier-free shower or something like that. So again, that might be something that changes while they're living there. Ramps are probably the most common thing that we get. Rails are other ones. Sometimes doorknobs can be a change, like somebody, it's easier to kind of use a lever than it is like one that twists. That can sometimes be a modification that is requested that a landlord might have to permit. Widening of doorways in a tenant's apartment. So that one's tough because I don't know that we would have to really examine the cost of what reasonable was in this. That is an expensive modification. And if a tenant is able to pay for it, it might be something that we have to go forward with. But again, there might be some undue financial burden on somebody who maybe needs that modification, and maybe, you know, even though a landlord is allowed to have that person put a money in deposit to, for whatever reason, narrow those doorways after they move out, there might be standing to be like, that's not, why would you do that? That's not reasonable at all. So I don't know. So the widening of the doorways is something that, like, I think is I don't know. Like I said, it's a depends answer. We always advise folks to put the request in writing. That doesn't have to be a formal letter. That could be a text, it could be an email. If it's a note, that just, you know, maybe it's not, who has their own personal letterhead, but like it could just be a note that's written, right? Somebody might take a photo of that note with their phone before they give it to somebody. But we do always ask, you know, we advise folks to put the request in writing, because that just creates a paper trail. And that makes kind of revisiting this, if the accommodation or modification gets denied, it makes revisiting why this got denied a little easier to investigate. But again, it's not required. I could just verbally ask for a ramp if I've got the documentation and the need for it. And I don't have, it's not legally required for me to put that in writing. And if the landlord says, no, I'm not going to do that because you didn't put it in writing, there might be standing for, you know, somebody in that situation who's a tenant to file a fair housing complaint against that landlord. Again, it has to be related to the tenant's disability, and we always advise folks to, housing providers, we always advise them to engage in what we call an interactive process. Like, don't say, your first answer shouldn't be no. If you're working with somebody and they tell you that their first answer was no from a landlord when they've asked for an accommodation or they've asked for a modification, that's probably something that we would investigate, because it doesn't sound like there was much, there was not much interaction between the landlord and the person that wanted to live there or does live there. So the biggest reasonable accommodation dispute we get is related to emotional support animals. Internally, we wondered if we should just name ourselves the Emotional Support Animal Fair Housing Council, because not only is disability the most frequently reported complaint, discrimination complaint we get, but more often than not, it applies to support animals and service animals. And I think this is where understanding non-visible disabilities is really behind when it comes to housing and housing practices, because a lot of, I think there is a lot of scrutiny and suspicion around folks who have a need for a support animal or a service animal, and landlords have or pet rent or anything like that, and are just trying to get around that and just keep an animal that is, you know, what I guess was legally considered a pet. Like, I had a dog, I had 2 cats. I think all pets do some heavy emotional lifting. I don't know what animal doesn't, you know, so that you live with. That's why we have them, right? Like, my dog was just like a dopamine on 4 furry legs. Like, he was great. Did a lot of heavy lifting, so I don't know. So there is, like, this is where, like, my opinion doesn't matter. So it does have to be related to a documented disability. The difference between legally, the difference between a pet and an emotional support animal is basically the ESA, the emotional support animal. It's there because of a disability. It could be someone has PTSD. It could be somebody. So dogs are wild. Like, you know, they can detect like somebody's blood sugar is getting low. So it could be because of that. You know, commonly we all think about the seeing eye dog. It could be that. Somebody could just, people talked about like dogs kind of helping them stabilize when they stand up from a chair or something like that. So it could do all kinds of stuff. The big difference, like I said, and this is where the dispute sometimes comes in, is like for pets, landlords can collect extra rent, they can collect extra deposits, and that can actually be a disqualifying criteria if you don't want to pay that. For a support animal or for a service animal, you can't do that because the legal equivalency would be that you're going to charge people to have their support animal, which is there as part of a treatment plan, as a support for their disability. It is tantamount to basically charging people extra because they have a wheelchair or because they take a medication to manage their chronic anxiety. So it is legally kind of the same thing. But like I said, there's a lot of dispute that people think that there is tenants who just don't want to pay pet deposits, and that I have personal feelings about it. I'm not going to go into, but well, I kind of did already. But there's not. Anyways, training isn't required for a support animal. That's a thing that does come up sometimes. There is no such thing as an ESA certificate. There's no such thing as ESA training. If you Google emotional support animal, you will come up with a page of websites. There's this cottage industry out there of websites that have people who are social workers like me, other healthcare providers who will charge a person for like a 10-minute text assessment, or they'll do like a 10-minute kind of email assessment, charge that person anywhere from $50 to $150, and then email them this boilerplate letter that just says this person should be allowed to have their support animal on airlines and in any housing that they are in. I hate those places just because, one, there's no such thing as a certification, and it's conning people into thinking that this is a legitimate thing when legally it's not recognized, and it's not, landlords don't have to recognize it. And then two, it charges so much money to people that they could get from so many other places that maybe they're already in treatment or care of, whether it's a social worker. It could be like a one-time assessment with a healthcare provider, a mental health care provider. Maybe it's just like a telehealth thing for like 30 minutes or something like that. But it has to be somebody who's actually interacted with the client, with the tenant. And above all, it shouldn't cost $150. That's kind of the big thing that this puts my hackles up a little bit, because I think it's exploitative to charge people that much money, because sometimes people's pet deposit maybe is that much, and I think people truly do need these animals who say they need them. And our healthcare industry costs a lot to even access sometimes, and sometimes this might not be as much as a pet rent, but it might also be less than a visit to the community health clinic. Some people don't even have access to health clinics or doctors. So again, this might be what people think are the things they need. But that's why also too, it doesn't have to come from a documented or licensed, registered healthcare professional. If you're in a support group, like a recovery support group, and you like maybe somebody's sponsor, you might be that person who can write that letter to somebody or on behalf of somebody that's like, what, I've been sponsoring this person a year, helping them in recovery. I think they benefit from this emotional support animal, helps, maintain their sobriety. Like that's a legitimate medical recommendation for this person's disability as defined by the Fair Housing Law. So again, I'll step off of the soapbox. That said, people who have ESAs are still liable for any damage that is caused by the animal. They still are subject to other rules too. They, if you have a dog, you have to clean up the dog poop that's in the common area. You have to keep it on a leash. Doesn't just give you, exemption from those things, because those are just the regular community standards of, what anybody would do. These are a bunch of scenarios that we're not going to do because I want to, I'm looking at the time, just hold some time here at the end of what questions anybody has. I know I've kind of interjected this a couple of times, but it's a lot of material. You do have handouts that will now sound more familiar to you now that you've been through this training. And it's gonna, things are gonna connect a little more when you review those, and you can have those as references to help you remember the things as well. But right now, this is what I want to, like I said, hold some time for you to ask questions about this. A couple of people have used the chat that talk about their own experiences. Like, I am somebody that can maybe help out with, like, if you're having a landlord issue now, or somebody that is. But I just kind of want to make myself and my knowledge available to you, just to kind of ask me these questions that you have. And if so, have at it. I'm going to unmute, or I'm going to mute myself. You can unmute yourself, ask the question, and then yeah, I'll answer it for you. And if you don't have questions, there's no pressure, but you'll get
I have a
time
question.
back. Okay, go ahead.
Well,
It says your
it's
name is
kind of like a question slash scenario.
Okay.
This is Gabrielle. I don't know if my name is showing up or not.
Oh, okay.
Okay.
No, it just says iPhone. That's okay. I was being just foolish.
No, that's okay. I'm Gabrielle Butler,
Okay.
and this is my first year of service with Elizabeth Village. So my scenario is a tenant moves into a house, and their rent is being assisted through Section 8.
Mm-hmm.
And so once they live there quite a while, they get their utility bill. They don't get a utility allowance. They're responsible for their full utility. They see that their utility bill is $600.
Holy cow.
Yeah, so they contact the landlord and tell them, something's not going on right here, and I don't think that the AC heating unit is, working correctly.
Yeah.
So the unit goes out completely. The tenant goes and has to buy, because it's upstairs, downstairs. The tenant has to go and buy fans, try to keep cool. Cannot open up the windows because the windows do not have screens in them. So eventually the landlord sends AC company out to see what's going on. They have to do reduct work, put in a whole new unit, and the landlord says, I'm not refunding you for those fans that you brought. And then on top of it, when the tenant gets their next utility bill after the system has been fixed, they notice that their bill's only running them $100 to $200. But the landlord doesn't want to be responsible for that $600 bill that they've been stuck with due to insufficient appliances.
Yeah.
My question to that is the landlord responsible for refunding for the fans that had to be brought? And is the landlord responsible for that $600 utility bill?
Yeah.
Electric. Yeah. Utility.
Yeah. Thanks. That is a common thing that happens a lot, and that is really frustrating to me because I'll tell you why, which is that there is, as I talked about, no certification, training, regulation that landlords have to go through in order to start renting the place out or accepting Section 8. So the Section 8 thing I'm going to come back to in a second. In general, though, what I will say is that those disputes, like where that resident lost some income or had to spend some of their own money to fix basically what should have been provided to them in their home, the only legal avenue they have to recover that money is through small claims court. There's not anything in the state or any cities that kind of take a look at those and regulate those and tell the landlord, hey, you know what, that was really screwed up. That person shouldn't have to pay for it. We're ordering you to repay them. There's nothing that actually forces them to do that. So the only option that people have is, like I said, small claims court. It's good and bad with that. The bad part is that it costs $50 to file a suit, and there is a limit on $2,500. That is the maximum amount you can seek in small claims. I guess the good thing about it is you don't need an attorney. You can represent yourself. You don't have to have an attorney to file for it. So there is like better access, even though there is like I said, that $50. But so that's in general. But you said that this person has a Section 8 voucher, right? Okay. So I am interested in do you know who the Section 8 case manager is for that?
Oh, I do not. I know it's Georgetown Housing, but I'm not sure who the actual worker is.
So I would have some questions for them about that, because usually Section 8 has to, that's the whole total amount of rent that the person pays for. It has to include the utilities cost as well for them to even say, okay, you can use your Section 8 voucher there. So I would wonder if the Section 8 office might actually be able to step in to do, like, help out with that.
Their
No.
only solution to pollution on that was that, well, that gives you a reason to break your lease if you want to.
Yeah,
That's not
really.
That's not a remedy. You know what I'm saying?
That's not.
So yeah, that was.
That is not a good answer from a landlord. So this is what I will say is, are you still in touch with this person?
Yes.
Gone through this. We have them call me.
Yes.
Because I will say this, I don't know if, based on what you told me, if it's a fair housing issue specifically, but what I will say, what's nice about our office is when we call places on behalf of tenants, sometimes suddenly landlords want to play nice because our office is called, even though they don't know that this isn't a fair housing issue. I would just pose it as like, I'm investigating it to see if it is a fair housing issue. But that said, I don't want to do that without talking to the resident first. But I'm going to actually, in the chat, I don't know if you can see this. My email is there as well as the phone number for the office. And my name is Drew. And tell them, you were referred from Gabrielle. Gabrielle, right?
Yes, sir.
Okay. Oh gosh, you don't have to call me sir. I'm too crass and lowbrow for that.
It's just out of manners.
I get that. I'm just teasing you. But yeah, you can tell them to ask for me. Gabrielle referred him over there because, like I said, I could refer you to legal aid or some other places. I don't know, especially right now with like COVID-19 related evictions going on, where they would get a quicker response. So I'd like to actually talk to that person and see if there's something that like I can just informally do to kind of help them out with it, and exhaust any kind of credibility or recognition that our office has before just saying like, yeah, the last thing that they would have to do is file in small claims court, which might still be the outcome. But I will give this a shot first. I'm happy to do that.
Okay. Thank you.
Yeah, no problem. Thank you for bringing that up. Anyone else got any questions or any scenarios like that you just want to talk out, troubleshoot, problem solve? 13 more minutes. I know everybody's also probably like, this is the end of the day, I want to go. But yeah, so I shared my email address and phone number in the chat. Actually, I will add one more thing. This is probably the important thing I should have added first. Our website has a bunch of information. I just sent that to Gabrielle privately. Let's type it again. This is our website. It has lots of information. There's also a portal on there. At the top of it, when you go to it, it says, request an investigation. Folks who maybe don't like talking on the phone, or maybe it's after business hours, they can go there and just submit an online complaint, and we'll follow up with them to just, get some more information and see if we are going to initiate a fair housing investigation to the dispute that they've got. So again, any of those three, phone, email, or just contacting us through the website, we will do our best to follow up as soon as we can. And we are kind of in the crux, the eye of the COVID-19 eviction storm right now, so it might take us a little longer than usual. So I do ask for a little patience, but yeah, we will follow up definitely. Well, okay.
This is Stephen Collins.
Okay.
I don't have a question, just more of just an observation. So these topics that we covered are rather uncomfortable, if that's if I could put a word to it, for both the the renters and the property owners. And I've come across situations where, maybe I've had to, force my way into renting a property. But, here I am, I'm living in this place where, now both parties are uncomfortable. The property owner, well, they didn't want me there in the first place. And, it just makes it a very uncomfortable situation for both parties, which is why I'm excited to be part of the housing opportunities of Northern Kentucky, where where we try to help persons just look, let's just forget about all this hassle and let's just move into a house that you can just call your own, and let's not worry about all this I don't know, drama. Because it just really does seem like a lot of unnecessary drama for everybody. And it's unfortunate that we have to deal with this, but it's just, we're dealing with human nature, and it's just unfortunate.
Well, it is unfortunate that the housing opportunities aren't as easily to come by for folks.
Yes.
History hasn't been very indicative that it's always been equal for everybody, and everybody's opportunities have been equal. So I do, and for that reason, I think it's a lot of extra work to discriminate against people and to just let people live where they want to live.
It is.
It is so much extra work. It takes so much energy, and it's amazing that people do that. Everything from like the landlord in Morgan County who wants to spend energy doing this, to all the lobbying work and policy work done to make some of this like legal discrimination law. Like, there's so much energy put into it. So yeah, I think it would be so much easier, people let go of that. Yeah. But yeah.
I like easy.
If that were easy, I wouldn't have a job, and I would be okay with that. There are plenty of other things I could do. All right, anyone else before we come to a close this afternoon? One last thing to show everybody, you made it, you got to the end of this very long training. You listened to me for 3 hours, and just got to leave you with some final Dwight Schrute gifts, because we're there, it's Thursday, you're gonna do whatever you want to do now, not sit through this. So yeah, thank you all for joining me, coming to this, and giving me your attention. Again, this is great information to share with people in the programs you're going to be in. It's great information from you. It's also just great information to be able to share with people that maybe housing is I think anybody who is interested in justice will find something of interest underneath the housing umbrella. Whether you want to work on behalf of homeless folks, obviously that's a pretty big one. Survivors of interpersonal violence, racial justice, disability justice. Like, so many of these things happen and interact under the housing umbrella that it kind of can become a nexus for a lot. It can become a home for a lot of the things that you want to see in the world. So yeah, I don't know. I always tell people when I get thrown into the penitentiary, I tell everybody that housing justice is what radicalized me, because it did. So yeah, so I hope I radicalized a little bit of you today as well. So, but again, my information has been shared. You can Google us as well if you didn't write it down. That's okay. I'm also going to name drop Terrell and Abby as well. They are fair housing advocates, and they will also be, in your orbit that you can reach out to. They know this stuff now, and yeah. So we will we'll be in touch, and never. Yeah. See, Abby's already started talking up there. So yeah, feel free to lean on them, lean on us. We're all in this together, and yeah, I hope you all have a great year, and we'll get this.
Yeah.
Stay safe out there too.
Yes, thank you so much, Drew, again for doing this training for our members and us. Lexington Fair Housing did a training a few years ago, or maybe it was last year. I don't know. It's been a wild year, but anyways, it was at the Stockyards, and it was awesome. So it's just a really good training just personally, you know, for personal reasons and for professional. So I always love hearing it. It's great, and we're
Wasn't
so
that a weird
happy.
place to have a fair housing training?
Yes, that's what Caitlin and I were talking about, but it was
Yeah.
so cool at the
Yeah.
same time.
That was when I wasn't with the agency. I was actually working at a greenhouse, and when I found out
Yeah,
about that, I was just, that's so weird. But I
I
hear the great things
know.
about it too.
Yes, it
Yeah.
was really cool. We were actually in like an auction pit thing,
So weird.
but it was really cool.
Yeah.
It was my first time being out there, but it was super nice, and they have a really great cafe or restaurant or whatever. But thank you
Yeah,
again.
no problem.
And I just wanted to say, just remind everyone that we will start up again tomorrow at 9:30 Eastern time, and we will see everyone then. And we will be sure to share Drew's information and Lexington Fair Housing's information with you guys as well.
Thank you.
All right, we'll see you guys tomorrow morning.